Good afternoon, everyone. This is South African Bar Association presentation. As you are aware, the South African Bar Association is a weekly event at no cost to the participants and viewers to improve the skill set of the legal profession. This initiative is aimed at making a fundamental contribution to developing the skill set of all and any persons who represents the South African public in our courts. It is my honor and privilege to introduce our eminent speaker today. Our speaker today is Advocate Kamogelo Maputla, whom is an expert in, amongst other things, competition law. Advocate Maputla shall be addressing us on a topic titled A Contemporary Perspective of South African Competition Law. It is the South African Bar Association's contention that we could not have acquired a more esteemed speaker than Advocate Maputla to be addressing us on the topic of competition law. Accordingly, during my introduction, I shall focus on Advocate Maputla's competency in his legal journey related specifically to competition law, as exhausting his academic achievements within other aspects would unfortunately result in the exhaustion of the allocated time. In that regard, prior to being called to the bar in 2012, Advocate Maputla worked at the Competition Commission. Ever since, he has been practicing competition law. He is an esteemed member of the Arbitrators Association of South Africa and a part-time adjudicator for the development of agriculture, land reform, and rural development. He is result-oriented and able to maintain a professional and positive performance regardless of the situation. Lastly, he has an honorable and respected name amongst his colleagues. In that regard, Advocate Bartford, who is a close friend, commented on Advocate Maputla in that he is one of the most learned counsel he knows, who is very approachable and exceptionally eager to share his knowledge. Advocate Ford is a participant to this presentation, and as such, I could be put to the proof thereof. A few housekeeping matters. These sessions are recorded, and we appeal to participants to ensure that your microphone is muted and that your video camera is switched off. Accordingly, during the address, all participants shall automatically be muted. If a participant has a question, simply raise your hand, or alternatively post such question using the chat function on the Microsoft Teams platform. Further, during the question and answer session, please restrict questions to the speaker relative to the topic under discussion, and only pose such question when called upon. Without any further ado, I now hand it over to Advocate Maputla. Over to you, Advocate Maputla.
Good afternoon, Ahmed, and to your attendees. Am I audible and visible?
Yes, Counsel, we can hear you and we can see you. Thank you.
Okay. Thank you very much. Today I will be dealing with the Competition Act. I propose to structure my address in the following fashion. I will quickly and briefly go through the entire act and then explain in a line or two what that means. Then I will specifically deal with Chapter 2 to the exclusion of Section 9 of the Competition Act, because those are the cases that we commonly see and experience when an anti-competitive conduct happens and affects the public at large. If one considers the Act, we would note that Chapter 1 will deal with the definition and interpretation, purpose and application of the Act. Chapter 2, which I will deal with specificity, deals with the prohibited practices. And then Chapter 2A deals with the complex monopolies conduct. Chapter 3 would be your major controls. These are the mergers and acquisitions. Chapter 4 would deal with the composition of the Competition Commission and the Competition Tribunal, their powers, duties, and roles, respectively, inclusive of the Competition Appeal Court, which is the highest court as far as competition matters are concerned. And chapter 4 would deal, 4A, I beg your pardon, 4A would deal with your market inquiries. These market inquiries are what we have seen through the market inquiry into public and private hospitals. Prior to that, there was a fight between Netcare, KPMG, and Competition Commission to try not commence with the inquiry. However, the South Gauteng High Court ruled that the inquiry should happen, and hence the inquiry has happened under the auspices of retired Chief Justice Sandile Ngobo, and the report is out in the public domain. A very good read to understand what happens in the public and private healthcare sectors and why those areas are very costly. And then your chapter 6 will deal with enforcements. This are, in a nutshell, when you have a claim against the, let's say, for instance, the bread cartel that happened, and you were a supplier of bread in a specific area, you would then approach the chairman of the Commission Tribunal to give you a certificate to issue civil proceedings in the civil court against those that were participating in the anti-competitive conduct. And if you are successful, you can be compensated with damages. Then your chapter 7 would deal with your breach of, these are the offenses. It will deal with breach of confidence. It will deal with penalties and perjury, etc., during the competition proceedings. And then lastly, you would have your chapter 8, which deals with the general provisions regarding the guidelines. This can be guidelines for mergers and acquisitions which routinely come out. This can be your guidelines as regard how a person can report excessive pricing under the pandemic, etc., etc. Now, without much ado, I would like to dive into the aspects of chapter 2. And before I get there, I would like to open by saying that Albert Einstein said it very accurately, that if you cannot explain it simply, you don't understand it well enough. I hope that my presentation today will be understood in the full flavor it comes and will be welcomed. And perhaps maybe in order to aid, let me just, Ahmed, is my screen being shared?
Yes, perfectly so. You would, if you don't mind, could you put it on full screen, Council?
Okay. Not this one. How do I do that, by the way?
I'm looking at the program using. I haven't seen such.
Okay, let me see. And then what is happening now?
No, now I can just see you.
Oh, you can see me.
It's no longer shared.
Okay, how do we do a full screen? Let me try in the interest of time. If not, then...
Oh, back, it says slideshow.
Okay, let me...
Screen.
Okay, let me see.
Split Council, but I'm going to try with you.
Okay. Is it fully showing?
If you go now to slideshow, it's on your... Yeah, there's slideshow. There's a tab called slideshow just above that. Above, if you move this above slideshow.
Okay, slideshow. And then?
Yes, if you click on that.
Oh, then we are in.
Yeah, okay, we're good. It's clear.
Okay. Thank you. As I've explained that I will be dealing with chapter 2 to the exclusion of chapter 9, it is very important that I define what is competition law for the benefit of all those that are listening. And I define it as it is that branch of law that deals with the effort or action of two or more commercial interests to obtain the same business from a third party. Now, my definition is motivated by the fact that competition law is best seen from the public law and not simply, excuse me, a form of private market regulation. And as I have explained to you that these are the cases that affect us whether we are aware or not, but they do, because price fixing, excessive pricing, we have seen it more often than not since the inception of the Competition Act, up until the inclusion of the regulations of the pandemic, wherein, I think just before the end of my presentation, I will quickly touch on that. Now, in the United States of America, the Sherman Act is the guiding legislation to look at anti-competitive conduct. And in South Africa, we have the Competition Act 89 of 1998 as amended. It's very important to have the amended one because you might just be quoting old law that is being repealed or being replaced with something better and more useful. Now, in order for us to look at Chapter 2 prohibitions, it is very important because to look at the definitional aspects of the words that will routinely come through the sections that I will be dealing with. Now, the first one would be an agreement. And the definition of the agreement is when used in relation to a reputed practice includes a contract, arrangement, or understanding, whether or not legally enforceable. Now, that is a very important note to make because more often than not, we see it at the Commission Tribunal say that, but you cannot prosecute us because this was nonetheless not legally enforceable. But the definition is all encapsulating to say that whether it's legally enforceable or not, as long as there is an agreement that falls within the parameters of what is defined, you will be prosecuted. Now, the second definition, which is equally important, it is a conceded practice, which means as a cooperative or coordinated conduct between firms achieved through direct or indirect contact that replaces their independence, but which does not amount to an agreement. Now, it becomes a bit confusing when you read it at first blush, but once you read it again, it starts to make sense. The third important definition that I've picked up would be horizontal relationships, which means a relationship between competitors. And if we would remember our mathematics, we would remember the x-axis and the y-axis, one representing the vertical and one representing the horizontal. Now, there are two distinctions between the horizontal relationship and the vertical relationship. The vertical relationship means the relationship between a firm and its suppliers, or both, a firm and its suppliers. So we will see later on how this can happen when I deal with how do we prove a case of a section. Now, there's also a new terminology that came in with the Sandvers case, the first constitutional court case that the Commission has ever pursued, wherein the term margin squeeze was first introduced to the South African jurisprudence. And the legislatures deemed it necessary to actually incorporate it in the amendment of the Competition Act. And it says, occurs when the margin between the price at which the vertically integrated firm, which is a dominant in output market, sells a downstream product, and the price at which it sells the key input to the competitor is too small to allow a downstream competitor to participate actively. Now, what this means, if you can just imagine a situation wherein you are in a corner and someone tries to push you further into a corner, this will give you an example or a clear indication of what the definition fundamentally means in real life. And it has been demonstrated in case law that we have seen. Now,
Counsel,
section,
sorry. My sincere apologies for interrupting you. I really want to have all the participants seeing your slides. We were both not successful on this because it's showing us 2 slides for now. Would you mind pressing the escape button or end show rather?
Okay, let me see. Exit. Yes.
Perfect. That's much clearer. Let's leave it like that. Thanks you.
Oh, okay. So this is more okay. No, fantastic stuff. May I proceed?
Please do.
Okay. Now, I see that, and please interrupt me every 15 minutes because there's a lot to say, but with the limited time, I'll try to be as eloquent as humanly possible. Now, section 4, and perhaps maybe I should not read what the section says, and I will invite your viewers to actually look at what the section says, but I will just highlight the important aspects to look at when you look at the section. Now, in terms of section 4A, the agreement or considered practice must be there. There must be a horizontal relationship, and there must be substantially lessening on prevention of competition. In the competition sphere, we call it SLC. And there's a rebuttal to that. It says, unless a party to the agreement or considered practice or decision can prove that any technological efficiencies or other pro-competitive effects, rather gains resulting from the conduct outweigh that effect of anti-competitiveness, which justifies it. Now, how do we prove a section 4.1a case? The case can be proved by demonstrating, amongst other things, consumer harm through high prices or limited output. What does limited output entail? If we look at what had happened in the bread cartel, there were certain provinces which were having less bread of a certain brand, and other places were having more. It's going to tie in with the other aspect of market division because it can be entwined. You make a certain product less at a certain place, so that whoever you're competing with or you have agreed to compete with will be the one benefiting. And through that benefit, there is consumer harm and the price would be high because supply versus demand, you are the one controlling it. And more importantly, it is very necessary to define the relevant market rather, because in order to assess the relationship between the firms, the market has to be defined. Because if the market has not been defined, we won't know that the firms are operating either horizontally or vertically. And at the end, we won't know how much impact it has on the end consumer. The test to use would be a rule of reason test, and the burden of the efficiencies would rest on the respondent firm to show that, notwithstanding the agreement, but let me show you the efficiencies that come out from this agreement. And under that circumstances, then they will not be found guilty. And the cases to consider on this aspect would be Trident Steel versus Dobile, and the citation would be 89 LM October 00. And also Netstar versus Competition Commission, 99 stroke Competition Appeal Court stroke May 10. The common one that we see would be your section 4.1b, which again is an agreement or considered practice in a horizontal relationship for price fixing or selling. Price fixing would be selling things at the same price. It is a synonym of one of the next. And then market division or collusive tendering. The market division I've just touched on earlier to say that if we are market participants and we decide that, look, in KZN, I'm going to sell Albany cheaper, and you who is based in Limpopo, you'll sell Sasco cheaper, etc., etc. That is how the market is divided. And then as far as collusive tendering, bid rigging, or the English parlance of loser's fee would fall under the collusive tendering case against a respondent firm. And this we have seen in the construction fast-track settlement process, wherein the construction firms that agreed to not bid for some work and bid for others, and that is how they divided the market, number one, and that is how they also agreed not to compete. So collective tendering, in a nutshell, would be to agree not to compete with a proviso that I will get something from the one who I am pushing to win. Let's take it as literal as lobbying someone to make it to a post. And once they are elevated to the post, they have to remember us who have helped him to be elevated to whatever post that may be. Now, these are per se prohibitions, and conduct must be characterized. The characterization of the conduct is very important because the conduct might have a fusion of all three or two. It might appear to be a market division and a collusive tendering. But if it is not characterized correctly, then a good case with merit can be one that will not be prosecuted successfully. And we have, there's a case, Competition Commission versus United South African Pharmacies. It's 04/CR Gen 01. These CRs will be the Competition Tribunal citations, and when you see CAC, it will be the Commission Appeal Court cases. And the leading one that anyone who has been through the learnings of the competition law would be ANSAC versus Competition Commission. This is a square bracket 2005, close square bracket ZA SCA 42. The decision came out on the 13th of May 2005. And then there is this beast called Section 4.5, which is single economic entities, which are exempt from Section 4.1, 8, and 9. 4.1 we have dealt with. 8 would be your abuse of dominance, and 9 would be your, let me just verify, price discrimination. Yes, that is the one that I will not be able to get to today. And wisdom from how these cases are assessed, we can find it in Copper World Corp versus Independent Tube Corporation. This is a United States case. It's 467 US 752 bracket 1984 close bracket. Also in South Africa, we can find the same wisdom from Patency, Citrus, Beher, and Bebrek versus Competition Commission. This is a 16-stroke CAC, April 02. The one which is the most recent one and is more elaborative would be your launch form versus Competition Commission. This is a 102-stroke CAC June 10. And then we are moving away from horizontal restrictions to the vertical restrictions. Now, under 5.1, the elements would likewise be an agreement between the parties who are in a vertical relationship, and their conduct has the effect of substantially lessening competition in the market they're operating from. However, that will not be so if a party to that agreement can prove that any technological efficiencies or other pro-competitive gains resulting from the agreement outweigh that effect that is being complained about. Now, Gaines said when we're proving such a case, we need to demonstrate the agreement, the conduct of SLC, and that there is no technological efficiencies or pro-competitive gains resulting from the agreement. Again said it is important to define the market and the substantially lessening of competition in the market, because this test is a rule of reason test that has to be applied. the reasons will beget whether the conduct is wrong or not. And the cases are Nkosi North, Ronald Msomi et al. Versus British Tobacco Embassy, square bracket 2002, close square bracket ZACT 49. The decision was out on the 30th of August 2002. Under section 5.2, we have to look at what the so-called RPM. It's saying that the practice of minimum resale price maintenance is prohibited. Very short section. Now, when we prove this case, we have to demonstrate that the practice of minimum resale price maintenance is implemented, number one. Number two, a minimum resale price is relevant to the commodity being sold. Number three, measures were in place to enforce that minimum resale price maintenance. Now, we will, moving on to 5.3, it states that despite subsection 2, which is the minimum resale price maintenance being prohibited, a supplier or producer may recommend a minimum resale price to a seller. Now, there is a proviso to that. This can only happen provided that the supplier or producer of the product makes it abundantly clear that makes abundantly clear to the reseller that the recommended price is not binding. Otherwise, it would amount to price fixing if it was binding. Now, alternatively, if the product has its price stated on it, the words recommended price, we ordinarily see it on soft drinks, Mova Coke. It will say long-term recommended 8 Rand, 12 Rand, or whatsoever is the current price. It has to appear next to it. Now, hence we find a situation where you go to a shop, he said, but it's recommended at 8 Rand, but the reseller is selling it at 10 Rand. He is allowed to do that because he is competing with other resellers for the same product. Now, wisdom for this kind of a case we'll find in Competition Commission versus Federal Mutual Aftermarkets, square bracket 2001, close square bracket ZACT 15. The decision came out on the 23rd of April 2001. Then we are moving swiftly to the dominance. Now, dominance is found under section 7, and it's the precursor to how we are going to assess section 8 and 9. It is also relevant to look at what amounts to dominance, because there are percentages that the legislature has enacted to demonstrate to a respondent firm who has that market share or market power, what would enable them to have dominance in a market in a specific operating sphere. Now, it is necessary to calculate the market shares from a research perspective, robust data, market studies, financial statements, annual reports, etc., because those are going to give us a clear indication that as regards this firm in this industry against its competitor, how much shares does it have? And once those has been assessed, then we can now try to find in the infraction of the firm in either 8 or 9. Now, I made a very interesting note to say that dominance or having market power is not an offense, provided that the firm having dominance or market power conforms to the standard or conduct designed to prevent that market power from abuse. So it is okay to have dominance, but don't abuse it, like we have seen in certain cases that we will touch on just now. Now, as regards section 8.1 of the Competition Act, it, in particular, A would be dealing with your excessive pricing. We need to demonstrate more often than not market shares equating to a monopoly, that would be a super dominant firm like Telkom. We need to look at history of historical support from the state, which would be your former ISCOR, now ArcelorMittal, and there has to be high barriers to entry into the market. Now, meaning that that dominance, when abused, is creating high barriers to entry. It means that there are less competitors which are able to enter the market. The respondent firm is, we have to look at whether the respondent firm is charging consumers excessively or partakes in unilateral conduct to take advantage of structural conditions in the market. Now, this more often happens when a respondent firm has power and has a lot of shares and infrastructure in the market and decides at what price it would charge. For instance, when the Telkom complaint was being assessed, one would see that it was more expensive to call in South Africa than outside South Africa because Telkom was operating as a dominant firm in the Republic. Now, the competition tribunal will assist in determining what price would be regarded as reasonable in relation to the economic value of the product in question. And for this kind of a case, we get wisdom from Harmony Gold Mining Company versus Mittal. This is a square bracket 2007, close square bracket ZACT 21. The decision came out on the 27th of March 2007. Now, under Section 8.1b, it would deal primarily with refusal to give a competitor access to an essential facility. Now, an essential facility means infrastructure or resource that cannot reasonably be duplicated, and without access to it, the competitor cannot reasonably provide goods or services to their consumers. Now, we can also give an example of the infrastructure of telecommunications. If Telkom decides that for a place like Gauteng, Pretoria, I am not going to give Neotel access to the facility that I have, but I don't want to service people in Pretoria. If I want to service them, then I'm going to charge them excessively. That is how the conduct can happen. Now, the case can be proved by demonstrating the dominance, but for the respondent firm having the essential facility, no alternatives are likely to take place when economically feasible to do so by a competitor. Now, wisdom from this kind of an assessment can be sourced from Commercial Solvent Corporation versus EC Commission, that is the European Commission. That is a square bracket 1974 close square bracket 1, CMLR 309. We also find it in Telkom, as I've mentioned, and that neutral citation would be Competition Commission versus Telkom South Africa Limited, square bracket 2011 close square bracket ZACT 39. The decision came out on the 23rd of June 2011. As regards the Section 8.1c, these are your exclusionary acts. And fundamentally, the exclusionary, other than those that are listed in Section 8.1d, because Section 8.1d specifically lists about 7 exclusionary conducts which are prohibited by a dominant firm. Now, for Section 8.1c, if the anti-competitive effects of that act outweigh the technological efficiencies or other pro-competitive gains, that conduct will be prohibited. Now, the case can be proved by demonstrating the dominance in a market that is being abused, because dominance is not a sin. the abuse of it is the same. And then the intention of extending the market power into a related market, be it upstream or downstream. Now, what that means would be that if Telkom as a dominant firm tells Neotel or MWeb, which are operating at downstream, say that, look, if you are to give these services for internet for South African Bar Association, I am going to charge you R1. However, you are not supposed to make a margin greater than mine. Otherwise, the facility will not be used. And now the bar would be in a difficult situation, wanting the essential facility, but is not able to do that. And the person who has that ability to actually open the market and make those facilities available is abusing their dominance by extending the market power into a related market. Now, I made a note again to say that in some instances, conduct specified in Section 8.1d may also be considered in the assessment of Section 8.1c. And we will look at margin squeeze, because the question of margin squeeze, as I've indicated, came through Senverse. And wisdom of all this we'll find from York Timber versus South African Forest Company, square bracket 2001, close square bracket ZACT 19. The decision came out on the 9th of May 2001. And more importantly, the first Constitutional Court case, Competition Commission versus Senverse, square bracket 2012, Z close square bracket ZACC 6. The decision came out on the 12th of April 2012. I would implore people to read this decision, because it has seen a very good migration of how conduct can be assessed. And then as regards 8.1d, it speaks about the inducement, refusal to supply, tying and bundling, and selling goods or services below the margin, which would be your predatory pricing. These are the 4 common cases that we more often than not see being prosecuted at the Tribunal Competition Appeal Court. And they are the ones that have as a matter of fact, any infraction to the Competition Act has detrimental effect to the general public at large. But these ones are the ones which have a long-term effect, because they have a long history when the conduct started. Now, where there's also the other 2, which are also equally important to assess under Section 8.1d, which would be buying up SASCA's supply of intermediate good or resources required by a competitor. And as I've always said, that this can also be assessed under Section 8.1c, because it has a fusion of margin squeeze. And then lastly, the engagement of margin squeeze, which we have defined from the beginning of the presentation. Now, the case can be demonstrated through the following. For the Roman 1, which would be your, let me just quickly remind myself. For your Roman 1, you would require to prove the dominance. You would require to demonstrate that there's incentive not to deal with the dominant firm's competitor. And you would also be required to prove that the incentive had the effect of inducing them not to deal with a competitor rather. And that the anti-competitive effects of the conduct are not outweighed by the potential pro-competitive efficiencies or technological gains that result from the conduct. And with this case, we will find wisdom from Competition Commission of South Africa versus SAA, square bracket 2004, close square bracket ZACT 31. The decision came out on the 30th of April 2004. Now, For an assessment of Roman figure 2, would also look at the dominance, the refusal to supply, the exclusionary effect, and the anti-competitive effect. And there must be no efficiencies or pro-competitive gains or technological gains that outweigh the anti-competitive effect in order for this case to succeed. Now, wisdom will find from Matla versus Independent Newspapers, square bracket 2006, close square bracket ZACT 84. This decision came out on the 6th of November 2006. And I think we need to move at a supersonic rate now. For an assessment of the Roman 3 of the exclusionary conduct, again, we'll look at dominance. The conditions to buy goods or services must be unrelated to the object. This will be your tying and bundling. For instance, if you go to Van Skype, they'll say, look, we're going to give you Harm's superior cost practice at R1. However, in order for you to get that thing at R1, you must first buy we must first buy the Erasmus at 3,000. So those aspects are the tying and bundling, and they are prohibited under the Competition Act and has to be prosecuted. And we will find the case dealing with that in the United States of America versus Microsoft Corporation. And again, the fourth one would be your predatory pricing. The assessment is similar to the other three, but we just have to here look at what has been charged below what the dominant company's margin costs are. And there must be no efficiencies in order for this case to succeed. And that wisdom we find from Nationwide Airlines versus South African Airline. This is a 2001 decision that came out on the 5th of January 2001. And again, for a case of failure to buy, the buying of scarce goods, there must be anti-competitive effect, and there must be no efficiencies available from that conduct. And again, we find wisdom from this United States case. It's Midwest Radio Co. versus Forum Publishing. And now, before I end, I would now like to touch on what has been assessed under the COVID-19 assessment. And we know that on the 19th of March 2020, the Minister of Trade and Industry published regulations under the National Disaster Act for the COVID-19 outbreak. Now, there is a new way of quickly and efficiently assessing these cases. And this we find under the Regulation 4, which has been promulgated by the minister, dealing with excessive pricing, which provides that in terms of Section 8.1 of the Competition Act that we have just touched on, a dominant firm may not charge excessive price to the detriment of consumers or its customers. Now, 4.2, in terms of Section 8.3F of the Competition Act, during any period of the national disaster, a material price increase of a good or service contemplated in Annexure A, which is the annexure is attached to the regulation, but the 2.1 says does not correspond to or is not equivalent to the increase of cost providing for goods and services or increase the net margin of a markup. Now, what this fundamentally means that when a person has received a tender for PPEs and they know that a hand sanitizer would cost them R1, but they are selling it at 50 Rand to whoever the end consumer would be it a government department or the malls that are required to actually provide for sanitizers. That is assessed under this regulation, and such firms will be found guilty of anti-competitive behavior. We have examples of Discam recently, and there's Babelegi. A couple of them have just come out who are engaged in this, and some of them have actually entered into what we call settlement agreements, or rather consent orders, in order to accept their fault and pay an administrative penalty, but not run the course of actually assessing the entire case in its full flavor. And that will be the end of my presentation. Thank you for your attention and time.
Council, during our conversation earlier, you had mentioned that you were concerned with your presentation during this program. I can confidently say that such concern was indeed unwarranted, as your knowledge on competition law is remarkable and your presentation was indeed commendable. I thank you for such an informative address. I have now opened a platform for a brief question and answer session. By way of a reminder, should a participant have a question, simply raise your hand. Alternatively, pose such a question using the chat function within the Microsoft Teams platform, where I shall pose the question directly to Advocate Maputla. Council, there is a question from Advocate Bart Ford. Advocate Ford, you can simply unmute your microphone and or enable your camera.
Good afternoon, Council.
Afternoon, Mr. Ford.
Thank you so much for a very informative session.
Sorry, Bart, can I interrupt you for 1 minute? Council, can you kindly stop sharing your screen?
Or how do I just click on this thing?
Perfect. Thank you so much.
Okay.
You make
so, Council, firstly, thank you for a very informative session.
No, thank you for the invite, Mr. Ford.
We didn't expect anything less.
I'm humble.
I've got two questions. The first is more of an administrative question in terms of, perhaps you can explain to us, where does the competition tribunal fit in, and what sort of decisions from the competition tribunal could be challenged by way of either review or appeal to the competition appeal court? And under what circumstances would one file a review or an appeal against a decision by the competition tribunal? Then the second question I'm going to ask you is...
No, can I? Oh, you want me to jot them down? Oh, I'm not good at jotting down. let me do that. So the first one deals with the administrative law, right?
Correct.
Admin law, review or appeal.
Correct.
Okay.
And then my last question has to do with, I'm not sure whether you recall, in 2000 there was this big Nedbank Standard Bank merger that did not take place. I think the issues there were the fact that it would have been against the public interest. I speak under correction. I think you would know better than I.
Yes.
If you can perhaps just touch upon there and then perhaps explain what was the rationale for that merger being declined by the Competition Commission. Thank you, Council.
Okay, thank you. Let me first start with the merger aspect. The facts, I've not recently looked at them, but where there is a prohibition of a merger, it would mean that there are competitive concerns which are to the detriment of the end consumer. Now, assuming that the merger, and I'm speaking from an assumption point of view, but the assumption is to try and demonstrate how this comes about. Assuming that the merger had went through, both Standard Bank and Nedbank operate in the same sector, which is the financial services. They are competitors with each other. They have a long history of banking. Now, there is commercially sensitive information which is prohibited from being shared. Now, the minute they are going to merge, it means that all the books of Standard Bank and all the books of Nedbank are going to be merged. There is going to be a duplication of seats. Now, the CEO of Nedbank and the CEO of Standard Bank cannot coexist since it has become an amalgamated institution. There has to be a sacrifice. Now, the reason why I'm confident in saying that is because when Telkom and there was a Telkom Bunje merger, which there was not a proper assessment of the competition concerns and the coordinated effects and the overall effects of what would happen should the merger proceed. Now, there was duplication of seats. And in the moratorium, they said 12 months, no retrenchments. But immediately after 12 months, there was a lot of job losses. So the motivation for the prohibition of that merger might be one of those. But up until one actually gets the decision, because more often than not, the reports prohibiting the merger would be a confidential document that the commission prepares for the side of, number one, the merging parties, and two, the tribunal. However, when the tribunal sits down and pens down a decision, they are going to pen down a decision for the benefit of the general public, excluding those commercially sensitive information. I hope I've answered you on the first one. Now, the second aspect on the administrative law, your question is very helpful and it should be asked. And I'm glad that you were bold enough to ask it. And I'm forever indebted to you. Now, in terms of Section 26 of the Competition Act, this is where the Competition Tribunal is established. Now, it reads, I'll read it verbatim. There is hereby established a body to be known as the Competition Tribunal, which has jurisdiction throughout the Republic. A juristic person is a tribunal of record and must exercise functions in accordance to the Act. Now, let's take, for instance, you are not satisfied that you are not given leniency for being a whistleblower under Section 41B. You were part of the people who were engaged in collusive tendering. You wish to challenge that decision. You are at large to challenge the decision. There is a little bit of a split between where you can challenge the decision, because there is a Similani, there's the Similani case which says that the high courts have concurrent jurisdiction. It's also found at Section 62 of the Competition Act, which speaks about the concurrent jurisdiction. Now, the High Court would have concurrent jurisdiction, what the tribunal can do. But if you are to really challenge what the Competition Act, and that is why an amendment was sought to say that under leniency, there is a definition of leniency under this Competition Act, which explains to us that leniency should you not be satisfied with an issue of leniency, it has to take place at the tribunal. However, the doors are not shut from respondent firms who continuously approach the High Court, which is wrong, because an assessment has to be made at the Competition Tribunal. And if you're not satisfied, you can take it to the Competition Appeal Court, which is the highest court as far as appeals are concerned. Now, what happens when one is not satisfied with the OKS? As regards the aspect of review, I am yet to see anyone challenging the rationality of the tribunal's decision on an aspect of review. What the respondent firms ordinarily do, they challenge the rationality of the Competition Commission's decisions under Section 40, the initiation. If I may find myself, 40, I was just doing it in the Supreme Court of Appeal the other day. What is it? Not 49. Yeah. Yeah, 49B. So when it comes to your dissatisfaction from the Commission's point, you can approach the Competition Tribunal and the Competition Appeal Court if the Competition Tribunal does not give you the justice you think you are worthy of. Now, as regards any challenge to the Competition Tribunal's decision, you can take it to the Competition Appeal Court. And if you are not satisfied with what the Competition Appeal Court says, traditionally, we have seen through the development of the jurisprudence, they used to take it to the Supreme Court of Appeal, which was wrong, because as far as competition matters are concerned, there is no common law issue that was in play. It was just purely competition law. What the jurisprudence should have done as back as 2005 was to say that when you're not satisfied, you should ask for direct access to the Constitutional Court, because more often than not, whatever is being argued at the Competition Tribunal has the impact of public interest, which the Constitutional Court is more than competent to deal with all those aspects. I hope I've answered you on those two aspects.
Thank you, Counsel.
Thank you, Counsel. Counsel, I have a question, or better put, a submission which would require your comment to such. There's been speculation in South African law in recent years regarding the nature and scope of the powers and duties conferred on the local competition authorities. This is due in part to divergent opinions in case law surrounding the nature and scope of the powers of the competition authorities, the interpretation of the provisions relating to administrative penalties, as well as the introduction of new criminalization provisions by the Competition Amendment Act 1 of 2009. I want to concentrate my question on the administrative penalty in terms of the Competition Act, that 89 of 1999. Currently, Section 59 of the Act provides that an administrative penalty may be imposed by the tribunal subject to certain conditions if a firm is found to have been engaged in prohibited practices. Such penalty may be determined and enforced in one or two ways, either unilaterally by the competition tribunal or in terms of a consent agreement concluded between the respondent firm in question and the Competition Commission and approved and enforced by the tribunal in terms of Section 58. Furthermore, in determining the extent of the penalty, the tribunal must take into account various other factors which you know of. It is my submission that the nature of the legislation is distinctively socio-economic. Accordingly, the remedies at the disposal of the Commission authorities should be viewed in the same light and consequently be seen to be used to provide equitable relief rather than to punish transgressors of the Act. What is your comment in that regard, Counsel?
Thank you for your question. It's immensely helpful. There is, I would reason it in two ways. Firstly, the administrative penalties, in my view, have long been determined and are no longer per se so detrimental, because if one has had sight to what the international jurisprudence do, when these people engage in anti-competitive conduct, they actually create a kitty for the 10% penalty. So when they come to the negotiating table, they already have the money, but they are going to ask for a discount. But that does not mean that the conduct is going to cease. Hence, you would see that notwithstanding the fact that there has been many penalties, some of the public concerns are still not addressed. Hence, your question to say that, or comment rather, to say that the redress should be targeted at the people who are injured by the anti-competitive behavior, which is true. But as a matter of law, the Competition Commission can only do so much. But it is time for innovative ideas, and perhaps maybe one should start writing papers in international journals to actually address that, because being in that field is, I'm more frustrated than you are, because when I go to my village and I'm asked, but you said there was a bread cartel which was stopped. Why is bread still expensive? Why can't the needy of that bread still afford it? And I have no answers to that, because I tell them, guys, those with ideas have no power and those with power have no ideas. But one day I will write something and it will be read the world over. Thank you.
Thank you so much, Counsel. Counsel, there's a question from Dr. Dexter Reinefeld. He's, thank you, so I'm going to repeat it verbatim. Thank you for your informative presentation, Counsel. My question, How will matters instituted during the COVID-19 pandemic be dealt with post the pandemic, seeing that the legislation passed during the pandemic is temporary, directly linked to the pandemic? Thank you.
Thank you, Doc, for the question. The default position will go back where I started with Section 7 dealing with dominance and 8. Now, after the pandemic, let's assume the pandemic is to come to an end tomorrow. The assessments will still go back to the original ways of robustly dealing with the respondent firms' financials and conduct, and really finding fault through the timeframes provided for in the Competition Act.
Thank you. I just want to see Dr. Daxter is typing. I just want to see if we've answered his question correctly. Just bear with me for 1 minute. He says thank you for the clarification. Council, there are a number of other questions from participants. However, time does not permit for such, and regrettably, I have closed the question and answer session. What remains is, on behalf of the South African Bar Association, we would like to sincerely thank you for your inspirational address and obviously your time. Appreciation to all those that have participated virtually and shall be watching this session at their leisure. These sessions are recorded, and the recordings can be found upon the South African Bar Association website, that being www.rsabar.net. I trust your Heritage Day celebrations are in order, and I appeal to one and all to observe the COVID-19 protocols during such celebrations. I thank you.
Thank you, Council. Thank you.
Thank you all.